When a person gets arrested and put into custody, they have two important things they need to do. One, to exercise their right to remain silent and not discuss the case any further, not give any statements. The police are not there or not concerned with the presumption of innocence. They need to obtain counsel and discuss the case only with an attorney, and that attorney will then provide them with information on how to proceed from that point forward. Once a person finds themselves in custody, they need to, as I say, get an attorney as quickly as possible. And the way to do that, there are several ways. They get a phone call from in custody to family or an attorney. Family can assist them in finding an attorney. That can be online, of course. That can be the phone book still, word of mouth, reputation. There are many ways to find an attorney. Bail is a matter of right to individuals in most cases, and basically it is a release, or a person is released into the constructive custody of a surety on a bond that they will assure the presence of the person in court. That's the purpose of bail. And bail is extremely advantageous to the representation of a defendant. A person in custody will find that environment extremely stressful, hostile, very difficult living circumstances. And the problem is, when they're in custody, all they can think about is getting out of custody. That's their primary focus. The case is not, and they're likely to resolve that case on the first offer that comes around. They just want out. They want sentenced so they can do an alternative program or something to get out of custody. The result is usually very negative. If the person, on the other hand, is bailed out, they're out of custody, they have much more time to work with their attorney, to meet with their attorney. The attorney can take the time that's needed to evaluate the facts and evidence of the case. The result is more effective representation, which means a better result at 99 times out of 100. The issue of whether to contact a bail agent or an attorney first, I don't know that there's a huge difference. If you can bail out, you're going to be able to obviously contact an attorney right there, or if you contact an attorney can contact people on your behalf to arrange for bail. So it can work either way. The important thing is, don't give a statement and don't talk about your case to law enforcement or any other inmates that you're maybe sharing space with. Important advice when you find yourself on the wrong side of the law, in the system as they say, is to not rush through the system. You need counsel to help you navigate the system. It's too complex, and you need to not act in haste, but work the case thoroughly and take the time it needs to, that is needed to examine the evidence and really get the best resolution possible. And that's only going to happen when you're not in jail, when you can take the time that is needed to discuss issues with your attorney and come to the correct resolution of the case. People in custody who rush to a resolution just to get out, there are consequences, sometimes life-altering consequences to those plea negotiations that they don't think about when they're in jail. And then they get out, and now their life is completely different. They have all sorts of like I say, lifelong consequences, perhaps felons that can never own or possess weapons, maybe they're registrable, things that could have possibly been worked out of the deal if there was more time for the attorney to prepare the case more thoroughly.